All rise. All persons having business before the Honorable Associate Justice Mayor Zajac from the District of Columbia Court of Appeals draw near and give your attention. The United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have just one argument before us this morning, and it is number 23 CV 781, Alexander Zajac versus Finnegan, Henderson, Farabow, Garrett, and Dunner. Mr. Zajac, and when you begin, could you just correct me if I've butchered your name and let us know how to pronounce it whenever you're ready.
Thank you, Your Honor. It's Alexander Zajac. All right, may it please the court. I think the theory of this case that's before you today is relatively simple. The question to be asked is can an employee be given oral promises to induce employment and then be denied those promises based on a non-integrated, non-binding offer letter from that employer? And so I think the answer obviously is that no, the employee would have a suit on those oral promises that were made. And that's really the issue before you here in terms of both the dismissal and the denial of leave to amend at the district court. Now, the reason this is pretty straightforward is I think the DC code in section 32-1301 makes it clear when wages are being defined that any contract is included as well as any remuneration promised, and that's pursuant to either a written or an oral contract. So in at least two different clauses, there's the idea that if an employer and an employee reach an agreement, a contract, if it's oral or written, that that must be provided. And so in this case, of course, we're talking about two different promises, one being the promise of a specific bonus for an amount of hours that was billed. And then the second being a specific tuition benefit if a certain level of grades were achieved.
All right, can you point to me in your complaint, your original complaint, if anywhere, that you said that oral promises were made that the productivity bonuses were mandatory?
Oh, sure.
I see it in your amended complaint.
Right.
I don't recall, maybe I missed it in your original complaint. And this kind of might depend on which, if we're reviewing the denial of the motion to amend or the original dismissal. Do you think you made that allegation in your original complaint?
Your Honor, I wish I had made it more clearly. Obviously, that's why I asked for leave to amend. I did. Let's see, I know in paragraph 16, that was more of a broad recitation. That should have been more specific, but
yeah, it was understood throughout the firm that these were mandatory, which is kind of a funny, it's kind of a funny claim. I'm not sure if that makes something mandatory. Every Halloween, I, sit at my front porch and I give out candy the kids come by. It might be understood by the kids in the neighborhood that every year I'll be out there giving out candy, but this year I might just decide I'm not into it. I don't feel like doing it. Do you think I have to? Do you think I've sort of promised that I would do it by my practice of doing it, or am I free to not do it this year? So, I mean, that all gets to, do you think an understanding among employees that bonuses are coming makes them mandatory?
Well, I think it would depend on where the understanding arose from. If it's a pattern or a practice year after year after year, I think that leans in favor of it being mandatory.
Oh, really? See, that's what the trick-or-treating example was meant to get at, to say, no, it doesn't. I could do that every year and then I can stop. Why wouldn't I be able to do that? Right. Why have I implicitly promised that every year I'll continue to do this? It's something that I do out of the kindness of my heart every year because I enjoy it. But I don't feel like doing it this year.
Sure. And Your Honor, I think I don't know that I'm necessarily going to, I stand by the sufficiency of the original complaint, but I don't know that it's necessary to this case. given Crowley's virtual presumption that leave to amend should be granted, and none of the, and the oral promises that are recited in the amended complaint aren't really contradictory with that customary practice. I'm not sure that whether paragraph 16 originally on its own is sufficient is, fatal to this case, or really the linchpin on which this should be decided, I think.
So help me with, if we're relying now on the oral promises, and well, let me ask you a question first. If we remanded and you made it back down, would it be your hope to rely on your amended complaint or your original?
I would hope to rely on my amended complaint.
Okay, and you've alleged that the oral promises are made by people who can bind the firm. How do we know that? What evidence do we have that a particular individual can change a firm's policy that's been stated in writing?
Sure, and I believe the amended complaint actually has that fact in there.
You're looking
You
for,
certainly stated. I want to know why it's not a legal conclusion.
Oh, sure. Well, I did, I attached an email message even in the amended complaint, where at least one of the individuals who made the promise explicitly said in writing that he was authorized to bind the partnership. But also, Your Honor, I don't know if it has to be fully given at this point. There just has to be enough facts for it to be plausible that someone who had the authority to bind the firm made that oral offer and that I accepted it.
so
And I
you're
think
pointing to, I think, paragraph 15 of your amended complaint, that on a phone call, Mr. Henderson orally promised a mandatory productivity bonus, and then the attachment in his email, which is still Mr. Henderson saying, I am authorized. And one might think, quite plausibly, a partner of a law firm would be authorized to engage in such a binding offer.
Oh, right, that's right.
That's what you're relying on?
15.
Okay.
That's right. And so again, given Crowley's, virtual presumption, again, I think that allowing me to rely on my amended complaint is probably the proper course of action here. And especially then, it's not as essential whether the original complaint really is sufficient or not. I think it is, but I certainly would have drafted it a little bit differently. Obviously knowing what I know now with the dismissal, right? So I'm not necessarily inclined to argue that unless that's something Your Honors want to discuss further, the original complaint. So I think in this case too, the two big relevant cases I see it as are obviously this court's ruling in Savaraman, where a moving stipend was categorized, I think correctly, as a bonus. It was made as an offer to induce employment, and then the employee accepted it and was not paid. I believe it was $2,000. And so I don't see how that's particularly different here than accepting employment and giving the hours that were, required, and then being denied a set amount that was told that would be paid out.
Are you referencing the bonus or the tuition reimbursement, or both with that argument?
For Savaraman, I think that would be the bonus. I think the tuition is probably much closer to Peck, the Peck case out of federal court here, where relocation costs and closing costs for a house were tied to an employment contract.
But why do we even need to look to the federal courts? Our own decisions in Savaraman make very clear that reimbursements for expenses are not wages. Why isn't the reimbursement for your tuition barred by Savaraman? Here, why is it any different than if someone were being hired you were hired as a student with the understanding that when you became a lawyer, you would come and work for the firm, and they paid for, and the understanding is they paid for that tuition. That tuition, why is it similar to someone being hired to become an HVAC installer? The firm, then the HVAC firm pays for the certification for that individual to become an HVAC installer. That HVAC installation certification is not are not wages under Savaraman. Why is that not the exact same situation with your case?
Sure, I think there were a few factors in Savareman. Certainly one was that the expenses that were being reimbursed were not considered income by the federal government. And in this case, you know, the tuition benefits.
Well, looking
were.
past the IRS, if you were to be asked what your wages were on that particular year, if someone asked you what you were paid that year, wouldn't you have responded, I was paid X in salary, not I was paid salary and tuition. That tuition was a reimbursed expense. No different than if someone asked the HVAC installer, how much did you get paid by the company that year? He would have responded the wages he was paid, not the certification to become an HVAC installer, not the certification or the tuition to become a lawyer. Why is this different?
Well, in this case in particular, it appeared on, you know, pay stubs and the W-2 that I received. So I do think if I were to, you know, just.
But
as a layperson-
how the IRS calculates taxable income does not equate to wages under the DC code. That's kind of a non sequitur. That's not what we're discussing here. So putting aside that, why is that not I want you to follow up with my analogy. Why is it not the same versus an HVAC to a lawyer? Why is it different?
Well, in terms of one thing in Savareman, I think, was that the expenses were not fixed. And in this case, it really was a fixed amount that was agreed upon. I mean,
So the distinction is that it's fixed as opposed to moving. That's the argument.
I think that was a large argument that was made by this court in Savareman. That whether a remuneration was a fixed amount or whether it was a floating, you know, expense. As you said, kind of we'll reimburse you for, you know, whatever you incur. The latter would not be included, but I think the former would. And if it's okay, I'd reserve the rest of my time for rebuttal.
Sure.
All right. Thank you, Your Honor.
All right, we will now hear from Ms. Fairley. Ms. Barlow?
Ms. Barlow, thank you.
Apologies.
Thank you, Your Honor. May it please the court, Trina Fairley Barlow for the appellee. Your Honors, the DC Superior Court's denial of appellant's motion for leave to amend his complaint should be affirmed for 4 reasons. First, the discretionary productivity bonus and the tuition reimbursement that the appellant complains about are not wages under the DC Wage Payment and Collection Law. As the court has.
Let's stop there. So when you say it's a discretionary productivity bonus, his allegations are no, it's not. Oral promises were made that it was mandatory. And why isn't that enough to get past a motion to dismiss?
It's not enough to get past a motion to dismiss for a couple of reasons. One, Your Honor, I think your trick-or-treating example is exactly right. In the original complaint, there was.
The trick-or-treating example would only work if what I also told the kids was, and I promise to be out here next year, and every year that I'm able and capable of doing it. You know, he has allegations of oral promises to keep to do this. And I stripped that out of my example. But anyway, I'm sorry to cut you off. Go ahead and run with that.
That's okay, Your Honor. It depends on whether we're talking about the original complaint or the amended complaint. In the original complaint, he did not have allegations of oral promises. What we had were his references to 2 offer letters, both of which explicitly stated that the productivity bonuses were discretionary. What we also had was in the amended complaint were brand new allegations that conflicted with the original statements that he made in his original complaint, and also conflicted with the offer letters that he relied upon in his original complaint.
Why?
Why do they conflict? They conflict, as the trial court pointed out, in several different places. And I can walk through some of those examples with you.
Well, I'll tell you, when I read it, I don't see why it's not just filling it in. Like why this is not just trying to add in to the pattern and practice and add kind of additional evidence to what originally was likely a very vague statement about this. Like where I don't see the direct conflict. So if you're gonna go through it, like if you could limit it to where the actual direct conflict is.
Yes, Your Honor. So at the amended complaint in paragraph 14, initially, or the appellate struck language alleging that the offer letter from the defendant clearly distinguished a discretionary merit bonus from a productivity bonus. Then in paragraph 15, the appellate struck language that during plaintiff's time as a student associate, that productivity bonuses were discretionary. And then in paragraph 20, he again struck language that admitted that his student associate bonuses were discretionary in favor of his new allegations that they were mandatory. And then we have to look at what he adds. In paragraph 15, he then adds allegations in the proposed amendment that an employee orally promised him a mandatory productivity bonus if he exceeded his billable hour requirement. These are directly contradictory to his original allegations. They also are
I still don't understand how. So help me out. What he says in his original complaint is, there's a 2016 offer letter that he relies on as a student associate, I believe is the title. That letter says that both types of bonuses are discretionary, as I understand it. He then says, I believe around paragraph 19, that after he passed the bar, paragraph 20, when he became an associate, productivity bonuses were no longer discretionary. Merit bonuses still remain discretionary. I mean, that's his allegation. So what's inconsistent with that in his amended complaint?
What's inconsistent is every reference to discretionary is taken out of the complaint.
But who cares? He never said that the associate productivity bonuses were discretionary in his original complaint. He never relies on any document that says they're discretionary. That refers to the student productivity bonuses, which he has always maintained are discretionary. And the fact that they are discretionary doesn't affect his complaint one bit, because he's not seeking to recoup a student associate bonus, but an associate bonus. So at what point did he contradict? At what point did he say, and I have to say, I haven't seen it, the associate bonuses after you become a full attorney are discretionary. He says in his amended complaint, no, they promised that it was mandatory. And I have not seen anything that contradicts that in the original complaint.
Well, what the appellant does is intentionally become silent on the core issues that go to the discretionary issues in favor of mandatory allegations. And this is relevant because it is directly contradictory to the offer letters that clearly say that it's discretionary.
So
But-
about that, should the court have even considered the second offer letter? From what we see in the record, Mr. Zajac was saying that his offer letter was destroyed. And I'm not sure our case law lets us go there without converting it to summary judgment, or even to consider that letter unless there's some admission of authenticity of it from Mr. Zajac, which I just haven't seen in the record and maybe I've missed.
Well, the trial court relied on DC case law that states that when a litigant references a document in the complaint, it can be attached without converting the motion to dismiss to one for summary judgment.
That's true, but did he admit that that letter was authentic? Like, his allegation was that that letter had been destroyed originally. And so I think that calls it into question a little more than just having referenced it, right?
Your Honor, yes, but below, Mr. Zajac did not challenge that. It can't be challenged the first time here. More than that, he still relies on references in the original complaint and arguments below that that at all times the bonuses were discretionary. I don't think, though, Your Honor, that that the case turns on that in any event. What the case turns on is a couple of things. One, even if this court doesn't accept the trial court's decision that the allegations conflicted, and there are other places which I can get to in a minute where they do conflict and they're problematic because, consistent with Harani, the allegations were changed in response to the court's order. Another example of where we have of that is with respect to tuition reimbursement. The court said tuition reimbursement are business expenses, so they can't be concluded to be wages under the DC law. And then in the proposed amended complaint, what we then saw was striking through references to tuition expenses and then calling them benefits in response to the dismissal, which is exactly what the court was
That just strikes me as a sort of conclusory label that you might throw down on something. So I mean, why don't we talk about expense reimbursements that were at issue in Savarimon and tuition reimbursement that are an issue here, and whether or not it really makes sense to say the two things are similar. What we said in Savarimon was, well, expense reimbursements merely offset a loss that is taken at the employer's behest. Tuition reimbursement doesn't seem like that. It doesn't seem like, hey, travel to Philadelphia, get a hotel room for a conference, we'll pay you back the money. You're definitely conferring an independent benefit on the employee. Are you not? When they leave the employment, they leave with a law degree that was paid for by their employer.
Yes, but this is entirely different than the moving stipend that we had in Savarimon. The moving stipend, the employee got regardless of whether they actually used.
No, for sure. I agree. But I think it's entirely different from both things that we talked about in
Right.
Savarimon, which isn't going to get you that far.
Yes,
So that just means we have to talk about what makes sense.
yes.
I don't think, I agree, it's not like here's $10,000, and if you can move for $20 somehow, you get to keep the other 9,980. But I also don't think it's like fly to Philadelphia and go to this conference and we'll give us your receipts and we'll hand you that, whatever your expenses are back. He's already in law school. He's enrolled in law school before he gets an offer. And so he's clearly doing it of his own volition. It clearly confers some benefit on him to get a law degree, as one would expect. So to me, it's more like buy a house. We'll pay you back for whatever you pay up to $1 million. That would certainly be considered wages. I mean, it's a reimbursement in some respect, but it's a reimbursement for something that is of personal benefit to the employee, not like an expense reimbursement to me. Why isn't tuition a lot more like that?
Well, in this particular instance, the offer letter and the student associate offer letter, which is the relevant one, so even if we don't want to talk about the associate one, it was pretty clear that it was subject to various conditions. So this was not a wage because it was conditional. He had to have a B average. He had to.
I don't understand why that would make something not a wage. You'll be paid $20,000 per month, provided you show up at least 4 days a week and are capable of billing at least 30 hours during those weeks. Those are subject to conditions, very obviously a wage, right?
It's not a wage because
That
it's
wouldn't be a wage?
discretionary. Yes.
It's not discretionary. Don't confuse discretionary and subject to conditions. If I say you're getting $20,000 if you check boxes A, B, and C, and you check boxes A, B, and C, I have lost my discretion not to pay you.
Yes.
That is a mandatory thing I have to do.
In your example, but in the offer letter, it was stated to be discretionary, it set conditions and stated that it could be modified.
Tuition was subject to be discretionary?
Yes.
Yes.
So I understand that's in the offer letter, but before we go to that point of discretionary, which I think is a whole other can of worms, and I'm very interested in your view on, how do you, and perhaps this is me phrasing Judge Deal's inquiry another way, how do we view this as anything other than an enticement to employment, like a recruiting tool, like a benefit your client's conferring to draw in qualified and perhaps preferred attorneys into their employ as opposed to them going elsewhere?
Your Honor, it may well be an enticement, but under Brady and Dorsey, that's not the standard, right? Whether or not it was an enticement. Here, what we have
But on
is.
Safariman, we talked about that moving benefit being an enticement.
Yes, but in order to get the moving benefit here, there were no requirements to get them. In Savarimon, there were no requirements to get the moving benefit. You just had to accept employment. Here, there were several other things that needed to be done, and that makes it different, right, than Savarimon. Again, there were conditions. It was discretionary, and the language made it clear that.
I still don't see where it's discretionary. So I'd like to look at the tuition letter for a second.
Sure.
I assume you're referring to the last sentence of the third paragraph, where it says the firm reserves the right to review the tuition reimbursement rate for students,
Yes,
student associates on a semester basis, and may at its sole discretion
Yes.
adjust the reimbursement rate.
that's
You
right.
can definitely do that before a following semester, But could you not reimburse him if he satisfied the conditions in a previous semester? I made Bs. I continued working for you. I've satisfied the two conditions, satisfactory in performance reviews and remained an employee of in good standing. Do you think at the end of that, you could say, we're still not going to do it?
Perhaps, but we don't have to
Why
do it
perhaps?
here.
Absolutely not. Like, obviously not. It says subject to those conditions, we will reimburse you for 100% of
That's
tuition
not really
expenses.
that's not really your argument.
That's
is it?
not
It's
my-
that you
yeah.
made the tuition reimbursement. You just weren't required to make it
To gross it
pre
up.
versus post tax.
To gross it up. Yes, Your Honor, that's exactly where I was going. And so this last line states that the firm reserves the right to review tuition reimbursement in its sole discretion and change the rate. And so he didn't allege that, first, there is no allegation that he was ever promised a post-tax tuition benefit, right? I think that has to be alleged in order to be able to state a claim here. There is no allegation that he was never paid any tuition. What he alleges is that he didn't receive tax benefits. There is no allegation in the complaint, nor could there be, that he was promised such a thing. So
He alleges a pattern of practice. Can you tell me why that doesn't matter? And perhaps, hypothetically, if he were able to get evidence from other folks that at the same time received that reimbursement, but they got it in the grossed up way versus the way he got it, would that not create a fact that the trial court should be concerned with discovering?
not on these facts, where he doesn't allege what the rate was, right? It's speculative. He's talking about what he understood versus what the actual facts are. You have to plead facts, and that's what the trial court concluded both with respect to the original complaint and the amended complaint, because
So on that point, why wasn't it error for the trial court to consider the associate letter that you attached in your motion to dismiss? Because that associate letter, he's challenging the authenticity of it. It's not like Tovar, where we're to presume under Tovar that the authenticity of the document is presumed. Here, he's saying, essentially implying that it's fake. I mean, that's essentially what's implicit in his pleadings. And why shouldn't we send it back to the trial court to build out the record on that particular point? Because plainly the trial court considered the associate letter in granting the motion to dismiss. In doing so, the record doesn't reveal that there was any analysis of whether or not the dispute as to whether it was authentic or not authentic, and what was granted or not granted, and what was implicit or not implicit. There's a lot of facts that were in dispute that were not addressed by the trial court and weren't subject to discovery, which seems to be jumping over the berm. And why shouldn't we just send it back to get it cleaned up?
Your Honor, if I may answer, the reason why you don't have to send it back is because those facts that you just went through are not dispositive to the case. What is dispositive to the case, if the court doesn't buy the conflicting allegations aspect, is that the alternative rationale is that was that adding the new allegations, even if accepted, were futile. And they were futile because the appellant did not allege the existence of an employment contract with respect to the tuition benefits or the productivity bonus. The DC wage payment law requires, given his theory of a contract, either an oral or written employment agreement. There isn't one, and there were no allegations of one. What we saw were some oral statements that he alleges that people told him about. And Mr. Henderson, as the record reflects, is not a partner of the firm. He's just an employee. So even if the court were to buy that he made these allegations, these hearsay statements cannot be contracts, nor did he allege they were contracts. He needs to prove that there was an employment contract, oral or written, and hearsay, conflicting, self-serving allegations, as the court concluded, don't meet that bar.
I see your time's up, but I still would like to at least ask you one more question on this point about the discretionary nature when it comes to the bonus. In your briefing, you've relied almost exclusively on federal cases. We have not directly addressed this that I've seen ourselves. And it strikes me that a lot of that, as I read those cases, came out of an original section of the statute that was later amended by city council when they decided that everyone was reading it too narrowly. What is the basis, or what's your best argument, including what's in your brief, for us to be persuaded to adopt that as the standard here when we're not bound to?
Understood, Your Honor. It's persuasive authority by a federal court sitting in the district interpreting the DC wage payment and collection law. The reality, Your Honor, is these cases should be persuasive, because if we ignore the plain language of the statute, which doesn't require that every bonus, right? It needs to be a bonus that is not discretionary, that is subject to an employment contract, oral or otherwise. And we don't have that here. And so if the court doesn't follow cases like Brady and Dorsey, it will open the floodgates. All a litigant would have to do is just say, despite having an offer letter that states that it is discretionary, despite having an offer letter that states that certain conditions must be met, all I have to do is say that some employee told me something, or there was an understanding around the firm that certain facts existed, and then everyone could state a claim rather. And that is not the intent here. And it certainly isn't the standard that should be followed here, where what we're really talking about is an abuse of discretion standard. The Mr. Zajac, the appellee, has already admitted essentially for the court to decide, but I heard him admitting that his original complaint wasn't sufficient. So we're really looking at the court's denial of a motion for leave, which is an abuse of discretion standard. And the trial court did not abuse its discretion when it determined that the new allegations conflicted, especially when they were very strategically changed in ways to directly address the motion to dismiss. And it did not abuse its discretion when it determined that even if you accept those, there needed to be, it's futile because there is no contract pled here. There are no facts in the amended complaint that go to a contract, oral or otherwise. And saying what people told you around the firm is not sufficient.
Thank you, counsel.
Thank you, Your Honors.
Mr. Zajac, I believe you have about 3.5 minutes left.
Yeah, thank you, Your Honors. And again, may it please the court. I think that the heart of the argument about contradictions, Your Honors already hit upon that. There really aren't any contradictions here in the amendment, and any change about discretionary is about a bonus that the employer and myself agreed was paid when I was a student associate. So there really isn't any reason that the district court should have, uncritically cited Harani and dismiss the case or dismiss the leave to amend based on that. Indeed, appellee seems to make a big deal about amending in response to what the court said the deficiencies were.
Before you move along, Mr. Zajac, help me understand, what is the relevance of you having been paid the bonus previously when you were a student associate?
I think the relevance is that regardless of whether that bonus was considered discretionary or mandatory, any duty was satisfied regardless. So since that's not an issue in the suit, it's really more background information in the complaint than it is a fact that gives rise to the claim in this case. If that makes sense.
Go ahead.
And so appellee makes a large deal over amending, like I said, in response to what the court said was deficiency. But that's exactly what happened in Crowley. This court characterized it as the plaintiff amending to, quote, address an alleged fatal omission, end quote, and that was okay. So I don't see any particular reason why the trial court should have denied me leave to fill it out in a way, right? To add these additional facts that I do think give rise to the claims at issue here. Your Honor's brought up the example of the house up to the $1 million. And And I know it's a federal case, but that's very similar to what was at issue in Peck and was held to be mandatory. The idea that there was closing costs up to a set amount that the employer promised to cover, and then the employer was held liable for those in Peck. And I think it's no different here.
What's your reaction to Appellee's point that Mr. Henderson is not a partner at the firm? So, relying on a phone call or an email suggesting he was capable of binding the firm. I'm not really sure where to go with that argument either. He was an unauthorized agent of the firm. I'm not sure if that was pled as a defense. I mean, really, none of this plays out, but do you have a reaction to it?
I think that to the extent, if the employer says he's not an agent, that's another factual dispute that weighs against settling on a motion to dismiss, I think, because that's a real factual dispute. The other is that the email attached has a partner from the firm CC'd who never denied his assertion of authority to bind the partnership. So I really don't know where that argument's coming from. It was never in any of the briefs. It's kind of just come up in oral argument today. But I do think it would just be another factual dispute that would have to be settled when the record's filled out, not here just on the pleadings. And I do think the only other point I wanted to make is that there is in paragraph 36 of the amended complaint an assertion about post-tax tuition benefits in addition to all the pattern and practice pleadings that were in the original complaint. So I'm not sure where Appellee got the idea that it wasn't pled in the amended complaint, but I do think it's there. And I see that I'm out of time, so there's no more questions.
All right. Thank you,
Thank you,
Mr. Zajac. Thank you both. We will take the case under submission and the court is adjourned.
All rise.